wanted to show you. Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated. Good morning.
Good morning.
Good morning, all.
I appreciate the court had indicated that there was some time the court wanted with counsel. I'm not sure, was that going to be over the lunch hour?
My thought is at the end of the morning before you go off for lunch.
Okay.
We would do that.
So my plan for this morning was to proceed now until say 11:15, have a break till 11:30, and then proceed till around 12:30.
Thank you.
The place I wanted to start this morning is to clear up a few points that I feel I did not give a fulsome answer to in when the court questioned. The first one has to do with the lost opportunity and what would have happened if there was an engagement process, and when we were discussing negative contingencies and, well, what if the Anishinaabe would have said, don't cut those trees down? Is that a negative contingency? And the answer is not cutting down more trees or extracting less from the resources in the past. It cannot be a negative contingency. Why do I say that? And I'm going to just stick with trees because it's a good concrete or wooden example to use. The short answer is because if less trees were cut down, the Anishinaabe would have both a share of the revenues from the trees that were cut down, and they would also have the value of the uncut trees that economics tells us would have a value of at least equal to the cutting of the trees. And as we sit in 2023, right now, the Anishinaabe have neither the money nor the trees. Now, I want to ask the court to recall Professor Stiglitz's evidence, and I'll just refer to it. It was on day 5, February 6th, 2023, at page 671 of the transcript, at lines 11 through 20. We were discussing really what can be called the value of foregone consumption. And he says, but the notion that for a rational individual, you give them an opportunity and you see that they deviated from that, that means that the thing that they choose was more valuable than the thing that you gave them. And so what he was getting at here is exactly what, as I understand it, in the Hayut case from the Specific Claims Tribunal, where I believe it was Arthur Hosius's economic opinion was on this very point, was agreed to. And in the Southwind case at trial, when the Prisman analysis was accepted by the trial court, it's the same point, that when you give up something, it has the same, it has a value to it. So you might recall that I think it was Professor Stiglitz talked about someone who's very hungry and has an apple that he doesn't or does not eat, or if he uses the money to buy an apple, the value of that apple is more than the rate of return that he or she could get by investing that money. So it deals with lost consumption still has a value. Now, I want to go into a little bit detail because it does seem a little bit counterintuitive, but here it is.
It does.
Yeah.
And I'll also just say, before you give that answer, I'll just throw two things into that.
Yeah.
One of the witnesses, I can't recall which one, in a back and forth with me, insisted that there was no value.
to land on which there was no economic activity. I'm not saying I agree with, obviously, I find that difficult to accept, but he said that's economics. The second thing I'll put into that is that my understanding of resource rents, as best I understand it so far, wouldn't have given a value to the land on which there was no economic activity. But I'm not as confident in that proposition.
Well, but the concept of resource rents, I mean, I can accept that. Actually, the second principle,
right,
that resource rents are the economic value of the available to of the resources that are available to be captured by their use. I think for our purposes, that's probably a fair statement, at least in my view. But that does not mean that land doesn't have a value if it sits uncut or unexploited. First of all, I mean, obviously, just think about it. It has sequestration value for carbon, right? That's just one example. But think about the value that it would have for an Anishinaabe person to utilize a forest that isn't cut down, to harvest the wike, the medicine, to have
for many people.
Right. Not actually quite true. Right. And there's aesthetic, cultural, social connect, not just for Anishinaabe, but for other people as well. So yes, it does have value, but the point that I think the court needs to remember is when we talk about loss of opportunity for the past, it's not just loss of a share of the resource rents. It's the loss. And so let's go back to my example here. The reason why there can be no negative contingency had there been an agreement to cut down trees has to do with the actual facts of history and the economic principle that I just cited from Professor Stiglitz regarding the value of choices made. And I want the court to work through an actual world, actually what happened example. And let's use an example where the Crown cuts down $1,000 worth of trees, 1,000 trees, with a resource rent value of $1,000. We're going to make it simple. The Crown chooses only to capture $500 of the $1,000 in resource rents. And we've said all along as part of this case that Crown should have captured more and we should be entitled to more, and we lost that opportunity. So the Crown shares the $500 with the Anishinaabe. And what portion of that $500 for this particular example or our discussion doesn't matter, whether it's 84%, 50%, 100%. They get something.
But let me just fill that in. They share the $500 that they captured.
Right.
Not that they didn't capture. Okay.
Not that they didn't capture. So far, that's the part of our loss analysis that deals with we're entitled to a share of what you did capture. Now, in my example, I don't say whether the $500 was captured directly or indirectly. We can assume it's both, right? Whatever the proportion for the Anishinaabe is, the lost opportunity is the lost opportunity to engage in a process by which the Crown would capture a larger part of the resource rents available to be captured, which would be more than just the 500, up to 1,000, not over 1,000, up to 1,000, right? Because there's $1,000 worth of tree resource rents to capture,
right?
But they only captured 500. So part of our lost opportunity would be to say, wait a second, if we had sat down, maybe we could have captured more of the up to $1,000 worth of the trees. So there'd be a bigger pie to share. We could also have sat down with them and said, remember Mr. Carney? He said that we could share the $500, sorry, you could still only cut down the $500, but when it came and not collect more than $500, but in your accounting with us, you could account on the basis as though you did extract the fair market value of the trees. So that's a separate.
And what's the difference between those two? In one case, you sit down and you convince the Crown, the Anishinaabe convinces the Crown somehow.
Or there's an agreement, remember.
Or there's an agreement.
Yeah.
That's what I mean. They convince them. There's an agreement.
Yeah.
To
actually extract more.
not to extract more because they.
Oh, sorry, actually.
100%.
I apologize. To capture more of the $1,000.
Capture more, capture up to $1,000.
Yes. All right. The difference between the two is that in the first instance, where they actually capture $501, $502, industry is actually paying more directly, right? So industry pays more.
Okay.
In the second scenario, which is the Carney scenario, industry still pays upfront the $500, but the Crown says, you know, it would be unfair for us not to consider in our calculation of the augmentation due that we could have and should have extracted up to $1,000.
So scenario 2 is the Crown.
Captured.
Crown shares with the Anishinaabe as if industry had paid more, or as if they had captured more.
As if they had captured the full value of what was actually exploited.
Okay.
Okay. So those are two ways we would have had a lost opportunity. Now, at this point, I want to remind the court that in this case, we are not claiming that let's go back. The total amount of resource rents is $126 billion. That's the world of what was actually captured and what was available for the Crown to capture. So in our argument before the court today and over this whole case, we are actually not asking for cutting, you know, the value of cutting down even more or extracting even more. We're in the world of what actually happened, right?
Capturable.
Capturable out of what was exploited.
Yes.
Yes. Now.
Or capturable in the words of Professor Stiglitz, not necessarily not all economists thought it was actually capturable. Well,
I don't think professors, the other professors said it wasn't capturable. I thought they had said that they didn't, in fact, know how much of it was captured.
Okay.
Yeah. Okay. But I want to go to the court's hypothetical where there was an engagement process in the past where there was an agreement to not cut down 1,000 trees, but to cut down only 500 trees. And again, for the same ratio, and instead of getting $500, the Crown gets $250, exactly half. So under that scenario, the Anishinaabe would have some portion of the $250, but they would also have the value, enjoyment, and utility of 500 trees that were not cut down. That is a loss as we sit in 2023. That's a loss because those trees are gone. They have been cut down. We neither have the monies nor the trees. Our loss is the same. Cutting down less trees is not a negative contingency given the facts of history in this case. So economics, remember, tells us that in advocating to not cut down 500 of those 1,000 trees in our hypothetical world, the Anishinaabe must, according to economic theory, have placed a value on those 500 trees that is at least as valuable as cutting them down.
Well, that's where you will find me stuck every time, because the economists are talking about money. And a decision, whether I make it or the Anishinaabe make it, a decision that 500 trees standing is worth as much as $500 from the harvested trees does not, in my understanding, gives me a benefit that is not measurable in dollars. That's what I thought I got from the evidence.
Okay, so let's try and unpack that just a bit. You've got the 500 trees standing, and I say that the value to the Anishinaabe in advocating for not cutting that down, according to economic theory, is it's got the same value, at least as valuable as the trees that were cut down. Right? But in the real,
in some measure, in some sense of measurement, it's got as much value.
it has to have as much value because
They gave up the money.
right, they're saying, don't give us our share of the $500 you would have got, because in our view, we're getting more value by leaving the trees standing. So that's Arthur Hosius's theory in Hayut. That's Professor Stiglitz's theory at page 671. And that's how you get that, why we say that it's incorrect to say that there is a negative contingency in the past. Because remember, those trees were cut down, and we did not only lose the money from those trees, we lost the value of those trees, and that's a real and genuine loss. So either the loss is a share of the revenues, or it's a loss in not being able to enjoy the trees, which economic theory is at least equal to the value of the trees.
I'm just going to ask you to give me that proposition again. When one chooses.
Well, whether it's by choice or, I mean, the Anishinaabe lost the choice, so to speak, of enjoying the money or the trees. And the value, the lost opportunity of enjoying the trees or enjoying the money from the trees is still equivalent. Right? Because when a decision is made not to cut down 500 trees that could get people $250, people are saying, or the Anishinaabe would be saying, if the trees are actually worth $500, right? The Anishinaabe would be saying, we think these trees that have an economic value of $500 should stay in the ground because we harvest wheat there. We put a value on those trees that is at least equal to the value, the economic cash value of the trees. Cash value and economic value are different things, I guess is the point. And our loss is not, can be conceived of as a loss of cash or a loss of value. And economic value to the Anishinaabe, and as you mentioned, to other people in Canadian society, there is a value that can be measured in economic terms by a proxy, which is the value of the thing that you gave up. And that's Stiglitz's point. If you give up something of $500 of value in exchange for leaving the trees, you're in effect saying, I value those trees at $500. But the problem is, in the real world, what happened, the trees are gone. We have neither the trees nor our share of the money. So that's why I say that there can't be a negative contingency in the past for advocating for cutting down less trees, extracting less resources.
Because you lost the decision-making ability.
Well, not only did we lose the decision-making ability, and I'm not sure I'd characterize it as a decision-making. It's not our decision to make. We lost the opportunity to engage, to have the trees not cut down, and that has a value to it, and the trees have a value to it. And either way you look at it, whether as money or value of trees staying in the ground, we've lost that. It's 2023, the trees aren't there, and we don't have the money, or our share of the money, excuse me. So it's loss of foregone consumption, really. Now, whether the court ultimately agrees with me or not, I'm hoping the court has my point.
I do, thank you.
Yeah, okay. So the second thing I wanted to clear up was the engagement process and co-management. Yesterday, the court asked me, so are you saying that the court should order co-management? And I said, no. We are not asking the court to order co-management. And I think that I just want to be clear that the court understands that in the engagement process for the future, the court must keep in mind my client's augmentation rights under the treaty are affected by every operational decision made about what resources to extract. And you will see in our Appendix A that we do seek in our relief that one of the topics for discussion and possible agreement through a future engagement process is co-management, not an order of co-management, but a discussion about whether co-management is appropriate. And we say, for an honor-bound crown seeking reconciliation, this is precisely what they would discuss, and co-management is a reasonable thing to discuss given the effect that resource management decisions have on our augmentation treaty rights. So although we don't ask for an order, we're not going to try and upset the constitutional order in this case. We don't ask for it. We do say that in the future engagement process, it is not unreasonable for this court to tell the parties that it would be reasonable and appropriate to discuss that topic. And we'll get to it again when I get to the final relief, but I didn't want the court to take my comments as though we didn't think co-management was a good idea. So before we left off yesterday, we were going through a list of factors that we said are really important for the court to consider in fashioning a just award. And we left off at a number of factors at paragraph 212 of our main argument. And the first of which I wanted to address is the idea that the proper remedy, not the cause of action, properly should guide this court's inquiry. We say that the quantification of compensation in any particular case before the court is a task of finding an appropriate and just remedy for breach of the specific compensable rights that are an issue. And I'm at this point, by the way, I'm following along my main argument at paragraphs 214 and following. As one eminent jurist put it, that's Justice Laforêt, the courts have tended to merge the principles of law and equity where necessary to achieve a just remedy. Justice Laforêt indicated in the M versus M case from 1992, and this is at paragraph 216, I quote from, "The truth is that barring different policy considerations underlying one action or another, I see no reason why the same basic claim, whether framed in terms of common law action or equitable remedy, should give rise to different levels of redress." And to some extent, I believe that the Court of Appeal in this very case appreciated this very touchstone, if I can call it that, when they opined at paragraph 258, "Fiduciary duty has no work to do in this case that cannot be done by the honor of the crown alone. The development of the doctrine counsel against imposing fiduciary duties where they are not required, and they are not required in this case." Now, I've already made the point, and I'll make it again, that treaties are sui generis relationship compacts. I don't believe that a breach of a treaty is a common law cause of action, or a breach of treaty is a common law cause of action. I don't think we need to worry about whether a breach of treaty is an equitable cause of action. What I do say is that the cause of action, whatever it's called, deserves a proper remedy, and the court can draw upon whatever principles are appropriate in a given situation. And on that, I think generally Canada in their argument agrees. Canada then, we're going to get into it, but Canada then says there's a couple incidents of presumptions in equity that in this particular case shouldn't apply, but on the whole, their principle that you look at the full suite of proper remedies is in accord with our view.
Yesterday, you said that you, I hope I get this right, that you had not found a case that listed or that defined the proper remedy for a breach of treaty.
Yes, and if the court is about to tell me there is one, I'm much indebted.
Sorry.
Yeah.
But so my question flowing from that is, when you say that a breach of treaty is a sui generis cause of action, is that your conclusion, or have we read that in some case?
Well, we've read that treaties are sui generis; they're not contracts, right? We went through that in phase
two.
Phase two, but
but that was not. Sorry, but that was not speaking about remedy as much as what they are.
Correct.
Okay.
Correct. And I think what I'm trying to draw on here is the Supreme Court of Canada's recognition in Southwind that really, even for equity, you don't just slavishly follow every equitable principle. It's got to be connected to the principle behind the compensation and the policies inherent in the breach or inherent in the relationship. And so what I'm trying to draw from the case law is, how should the court develop a principled approach to identifying what are the proper remedies for breach of treaty? Because, well, we know it's a sui generis compact. It's not a contract. It's not, so it's something different. And if the focus and the reason for equitable compensation is to enforce the relationship between the fiduciary, my argument is, well, wait a second. All that has been written about treaty is about diligent and purposeful implementation of a solemn promise that must be fulfilled in accordance with the terms. So we have very much, and in order to pursue reconciliation in accordance with the honor of the crown. So we have very much in treaty fulfillment, like in fiduciary law, like in equity, a focus on the relationship. And that is really, quite frankly, what the Supreme Court of Canada has said is important about treaty and Aboriginal rights fulfillment. And I think it was in paragraph, I think it was paragraph 1 of Mikisew, where they talk about, of 2005, where they talk about the hopes, aspirations of the various peoples. But it is reconciliation to which treaties are ultimately, or fulfillment of treaties are ultimately for the purpose of seeking reconciliation. And that shares very much with the equitable concerns over relationships in the fiduciary concept. And so I'm trying to draw from the case law indicia or guideposts, if you will, to help the court craft a just remedy. And I started from the proposition I just had cited, that, which is Justice Laforet's, that don't be so worried about the what you call it. Be more worried about what finding a just remedy that addresses the issues at hand, addresses the nature of the claim and the nature of the breach and the conduct of the party in breach, etc.
This sounds like the old days when we were encouraged not to focus on the rules of hearsay, for instance, and directed to take a principled approach and look at what was the harm that was trying to be avoided and
yes,
benefit.
Yeah, I think that's a fair analogy. Yeah. Yeah, I mean, that's, let me, do you have more questions or should I?
No,
Okay.
I'm just putting that out as you have made this argument in your written submissions and on your feet, that harkens back to those early days so long ago of developing this notion that one should take a principled approach as opposed to.
And I'm saying the Supreme Court of Canada in Southwind and Justice Laforet in M&K is saying you should do the same. Now, that is not to say I'm not advocating for the fusion of law and equity. Not at all. I am advocating for a just remedy for every wrong. And what that just remedy is depends on the nature of the wrong and the rights in question and the goals sought to be achieved. So to continue on with my submissions, I just wanted to contrast for a moment common law damages. The purpose is to put the party whose rights have been breached whole by putting them in a position they would have been had the contract been performed. That's generally called expectation damages. Meanwhile, inequitable compensation, which is equity's common part, it's often thought of to restore the actual value of the thing lost through the wrongdoer's breach, referred to as the plaintiff's lost opportunity. That's from Southwind at paragraph 69. Now, as for the difference between the two, the Supreme Court, and this is between common law and equity, so the Supreme Court of Canada explained that equitable compensation differs from common law damages because of the unique foundation and goals of equity. So the determination in this case for breach of treaty, we say must consider the unique foundation and goals of treaty implementation in Canada, and that the proper approach to quantifying monetary remedies for breach of treaty, a constitutionally entrenched relational agreement, should not depend on trying to pigeonhole it as a common law or an equitable cause of action, but to borrow from both where it's appropriate to do so. We say there is no magic in calling an award you might give as compensation as opposed to damages. The word used is not what matters. What matters is that the award is just. So the court must consider the treaty obligation, the conduct of the party in breach, and the purpose that any award seeks to achieve. And with that, I get to my second criteria, which is the unique nature of treaty rights in general. So the unique place that treaty rights fits within our constitutional structure, and here I'm referring to our paragraph 226 of my main argument. The unique place that that treaty rights fit within our constitutional structure help, I think, define the nature and scope of the appropriate remedy for their breach. The Robinson Superior Treaty, we remember, the court will remember, was a product of the kinship relationship among parties who were renewing their relationship of interdependence in 1850. Now, in that compact, in that treaty, there are specific obligations set forth aimed at achieving a particular purpose. The important societal relationship and the reconciliation sought to be achieved must weigh heavily in the balance. We say that the Robinson Superior Treaty is a foundational compact on which our nation rests. The Robinson Superior Treaty is the consent instrument by which the Crown, whether Canada or Ontario, secured meaningful administration and control over the treaty territory, and by which it was granted and secured the right, but subject to the promises therein, to use the lands and resources within the treaty territory. Now, I pause for a moment on the issue of subject to the promises therein. It matters not whether those promises are Section 109 rights. Now, Canada and Ontario might want to fight about that, but it's not our fight. We don't allege that the interests are proprietary interests under Section 109. But they are interests nonetheless, and very important interests that the Constitution says must be diligently and purposely fulfilled. In light of the foundational nature of treaties generally, considering them as quasi-constitutional instruments is an apt one, and there's a very interesting discussion on that by Jana Promislow in an article written in 2014 called Treaties in History and Law. I don't need to go to that.
Is it in the book?
Yes, or it should be. It's a footnote 134.
In your material?
In my material.
Okay, thank you.
Yes. The appropriate remedy, therefore, when there has been a breach of treaty, must take into account its foundational and constitutional dimensions. I then turn to, well, what goal does the treaty promise seek to achieve? If we're going to look for a proper and just remedy that addresses that, what is the goal? What is the purpose behind the promise? Well, the first thing I say, it's a sharing of economic value. The treaty annuity augmentation promise has as its core a sharing arrangement that the Crown is honor-bound to implement diligently and purposefully. The thematic goal is set forth in the judgment at paragraph 2B, where the court discussed the common intention was to realize the future opportunities and potential of the treaty territory. Consistent with reciprocity, renewal, and the like, and justice, fairness, liberality, benevolence. I think the court has my point on that. The overall tenor, though, of both this court and the Court of Appeal was that the parties intended to share the wealth of the lands and resources on a wait and see or an if and when approach. That was central to the treaty promise. Moreover, in deciding on an appropriate quantum, the principle of reciprocity needs to be fairly considered. Reciprocity was and remains an animating principle for identifying the proper and just award for this case. Now, remember that reciprocity was understood in 1850 by both the Crown and the Anishinaabe as requiring a return to the Anishinaabe of that which was commensurate in value to what the Anishinaabe bestowed on the Crown. And recall as well that the value we're talking about is economic value. And both this court in stage 1 at paragraph 419 talked about economic value, and I don't have a cite for it, but the Court of Appeal also reiterated that it was economic value that is being talked about when we talk about reciprocity. Reciprocity, taken together with the kinship metaphors employed by the Crown in 1850, require, says Dr. Dribbin in his report, and that's at Exhibit 14, pages 69 and 94 from Dr. Dribbin, that the annuity augmentation to be made in any given period will be the maximum amount that the Crown, as a loving, caring parent, could bestow upon its Anishinaabe children. And again, here I will pause to say an obligation to share as a loving parent, if that is the litmus test of that, or one of the litmus tests that the court must take into account, does not create a fiduciary duty. It helps define the quantum, a totally separate thing. Next, the economic value of what the Anishinaabe brought to the table must be an important factor in considering quantifying the compensation. Similarly, economic value and reciprocity also need to be taken into account when the court turns its mind to devising processes and procedure for future implementation that the parties have not agreed to. And of course, I need only refer to paragraph, the Court of Appeal at paragraph 272, where the Court of Appeal says the parties and the court should be led in defining, I'm paraphrasing, in devising processes and procedures for implementation in the modern era. The parties in the court should be led by the treaty's shared goals, expectations, and understandings in 1850, including I'm going to call them the 4 R's at this point, if that's okay. And the Crown's commitment to being both liberal and just. Now, when we talk about what the Anishinaabe brought to the table, I think in the evidence there was a little bit of a difference of opinion ultimately between Ontario's experts and Stiglitz and Hutchings and the plaintiff's opinion, the plaintiff's position. The plaintiff's position is that what the Anishinaabe brought to the table is the economic value of the territory, which is which by definition is the resource rents. Now, in our argument and in our proposition, we said that the value of the resource rents and the value of what was brought to the table are the same, and that's the full amount of the resource rents that were actually captured, 126 billion, and brought forward at 60/40. Ontario's expert Bodway actually had a different view.
Can I just be sure I have this right? When you use the word actually captured and you're 126 billion, I just want to make sure I understand the word actually. Is that directly and indirectly, or those are the economic rents?
No, those are the full economic rents captured by whomever in Ontario.
Right.
Right. So of that, remember yesterday we talked that it was about 77 billion directly and indirectly actually captured by the Crown, but actually captured by somebody was 126 billion in value. And what I'm getting at is that there's the value of the lands and that what the Anishinaabe brought to the table. And as I understand it, we said the two are the same and and we're advocating that it's based on the full amount actually historically captured by somebody of the resource rents, not what could have been captured, but what was captured. And I know there was some confusion, I think early on, the experts, Bodway and Smart, in their material, in their reports, had said, oh, Professor Stiglitz is trying to capture more than what actually happened. Well, we're not. But in cross-examination, you might remember, and I think we'll get to it later, Professor Bodway said, well, if you really want to measure the value of the treaty territory, it's not what actually came out, it's the potential. So he would put it even higher. He did not, and I don't want to overstate his evidence. He didn't say, well, that's equivalent to what they brought to the table. He didn't, it was unclear to me from his evidence what he said that was.
He was sticking to his lane.
Yeah, he was sticking to his lane about economic value as opposed to brought to the table. But we equate the two at 126. He says it should be, and no one knows, by the way, how much more the optimal is. We know it's something, right? But the fact that he understood that if one was concerned about the value of what was of the treaty territory itself, that's the figure one would use, not the lesser amount that Stiglitz and Hutchings used. So a factor for the court's consideration. Once again, I want to repeat that the shared goal and expectations of the parties in 1850 was to share in the economic value of the lands and the resources within the territory on a wait and see approach. And that should be a factor. Now, we get to the Anishinaabe goal of achieving Minnow-Bemadzwin. And the Anishinaabe in 1850, although they wanted to share in the economic value, they didn't have actual dollar amounts in mind. They had results in mind. And that was that's the reality of the situation, according to Dr. Dribbin, that they were looking for the best possible outcome, if I can paraphrase it that way. And this actually, Dr. Dribbin's evidence about this was actually remarkably consistent with the idea of the Court of Appeal that one should not take into account simply a mathematical approach, but one needs to take into account the relative wealth and needs of the parties. To an extent, the evidence from the lay witnesses was the good life had some variability as to the accoutrements needed to advance towards the ideal of Bemadzwin. So, for example, offering a hand when help when help is needed, shelter, sustenance, nutritious food, good education system, good health care, not just the basics, but thriving, the best possible life. And that's from Dr. Dribbin, Exhibit 14, pages 74 to 77, the last one. And I'm reading from page 2, paragraph 244 of my main argument. Dr. Dribbin was the only expert witness to testify on the subject of Bemadzwin, And he opined that the Anishinaabe in 1850, as we said, they weren't focused on dollar amounts per se, but were focused on such matters as kinship, reciprocity, and outcomes. He opined that the outcomes that they expected would be the outcomes that a loving and generous parent would provide for their children. He explained that the annuity was not intended as a proxy for a moderate livelihood. His opinion was that achieving Bamadzwin, the good life, means thriving and living a life with mental, physical, and spiritual health. He identified, in addition to the specific factors identified by the Court of Appeal, an absence of range of deprivations, including housing and potable water. There are other socioeconomic wellness factors or indicators on which to assess relative disparities. Dr. Dribbin specifically identified income, employment, education, family solidarity, language retention, housing, life expectancy, infant mortality, and relative freedom from disproportionate sexual assault and incarceration. In respect of each of these indicators, First Nations continue to lag far behind. Remember, the lay witnesses and Dr. Dribbin spoke of the 7 grandfathers, and Dr. Dribbin wrote, proper implementation of the augmentation clause would maximize the Anishinaabe chance for success. That's at page 78 of his report, Exhibit 14. And the collective annuity would help the Anishinaabe overcome economic challenges and hasten the return to the way of the good life. Again, Exhibit 14, page 83. We asked the court, based on the evidence in stage 3, that the clear and consistent evidence of the Anishinaabe was that they had an expectation that what they bestowed upon the crown would be repaid with generosity and would be in such amounts as would allow the Anishinaabe to achieve the best possible life. At the core of Dr. Dribbin's testimony, and a common thread running through each of the lay witnesses' testimony, was that Bamadzwin, the good life, whatever it means in terms of physical things needed from time to time, would be a sum that would achieve for the Anishinaabe a life that is no worse off than the non-Aboriginal population in their midst. And I think that is why the analysis of the income disparities that range from 153 to $196 billion is an important figure, because not because, by the way, we are not suggesting that the award here should be $196 billion. It can't exceed what could reasonably have come from the treaty territory. It's got to be tied to the productions of the treaty territory. But the court, in considering what share and what amount should we impute as shareable, one of the factors the court should take into account is, well, this 153 to 196 billion, again, at 60-40, I acknowledge that, but that's the numbers that were before the court. Those amounts represent a true and fair identification of the disparities suffered by my clients and by the Robinson Superior Treaty Anishinaabe, that the core of the treaty was meant to prevent. So if the potential of the resources was not 126 billion, but was 210 billion, I would be saying that the 196 billion is the proper number. But because in our analysis, and as conservative as it is, we end up with 126. I think I have to be limited to that. Bemadzwin, in effect, seeks substantive equality. An award that is quantified by reference to an amount, or in considering an amount historically that was needed to bring about substantive equality for those who suffered and for those who continue to suffer. It actually makes good sense, and it would not be wrong. And here, I believe, at one point, Canada in their argument suggests that we're asking for more than the 126. We're not. We're limiting ourselves to the 126. We're not asking for a share of the 196. We're saying that the 153 to 196 informs the proper sharing of the 126. The court has that point, I hope, yeah. Okay. The next factor that I want to turn to, and in fashioning a just award, is this nature and importance of the relationship that the award is intended to foster. And here there's tremendous analogies to equity. We say at paragraph 255 that the Robinson Treaty is a foundational instrument that predated Confederation and whose promises are now constitutionally recognized and affirmed. It is a constitutional imperative. And we make the point at paragraph 257 that while fiduciary duty is not at play, there remains a treaty relationship. Now, that treaty relationship has been described as a fiduciary relationship, and it is a relationship to which the honor of the crown and reconciliation are pledged. So the nature of the relationship, we say, is an important factor for you to consider. You might recall that, or I would put it this way, fiduciary law is concerned with the important relationship at the heart of the obligation, and an award for breach of treaty must appropriately foster respect for the rights, the treaty rights at issue, and in a way that deters future breach and enhances the relationship. In the analysis of a proper remedy, therefore, as in equity, consideration of how an award will affect the party in breach, how they will conduct themselves in the future, is a relevant consideration. And in this case, we urge the court, based on the evidence, to conclude that the Crown's conduct in the past has been wanting, and their actions continue to suggest that they have not yet embraced the admonitions of the court to act with honor. The evidence of the conduct of the Crown post-treaty was tendered largely in stage 3, largely through the evidence of Dr. Von Gernot, and to some extent, Gwyn Jones, was directed at trying to establish, at least this is my understanding from Ontario's argument, that that if there was a breach of treaty, it was innocent. Now Ontario says, well, we didn't breach the treaty at all. But I gathered that they were trying to say we did our best. The argument I think Ontario wishes to advance is that to the extent the bona fides of the Crown conduct, to the extent that the bona fides or the goodwill of the Crown's conduct post-treaty is relevant, they, the Crowns, in all respects acted reasonably even as they breached the obligation as found by the court to exist, and did so innocently. We say the evidence does not support that the Crown can claim to have acted innocently, diligently, purposefully, or in a manner that is proper in accordance with the honor of the Crown. Recall that immediately following the making of the treaty, the augmentation promise was ignored. No matter what interpretation any Crown official might reasonably have had, each interpretation required the Crown to engage in a process and keep track of relevant revenues from within the treaty territory. Respectfully, that was not done. Being there was no engagement process, there were petitions of grievance in 1851, 1852, 1869, 1870, and 1874. This is from paragraph 266 of my argument. And they were simply ignored. And I think the court can also take note of the Crown's refusal in the last 5 years since the 2018 judgment to engage in a process. The Crowns have gone about business as usual, even as my clients in the Robinson, Superior, and Anishinaabe continue to suffer. Their conduct.
This is a point you have made in your submissions. And,
Yeah.
And the part of the response is, did you ask for anything? Any process since 2018?
Well, their evidence from the lay witnesses was that, yes, we did. I don't have the citation, but I'm pretty certain that some of the lay witnesses indicated that they had, and certainly I'm not exactly sure what direct evidence there is about not engaging in a process, but I'm fairly certain that there is evidence of that. And maybe we'll just look into it and try and get you a better answer for that. We would say, though, that it would be diligent implementation requires the Crown to reach out. It wouldn't in any event be for us to say we asked for it. Diligent implementation requires positive state action. It is for the Crown, put it this way, it's not for us to say you owe us an obligation. It's if the obligation is known, it's for the Crown to engage in it now, to diligently pursue it, right? That's what the law says. Law says if there is a treaty obligation, Crown actors must conduct themselves so as to fulfill that duty. And, the treaty rights, or this particular treaty right, is kind of unique. And I think in my argument, I will get into that about, we're going to get to it shortly, that there's not a lot of constitutional obligations that require positive state action. But where there is that requirement, the duty is on the state, the Crown, to initiate it, not to sit back and wait for complaints to be made. We also say that there has not been any genuine attempts to keep track of relevant revenues and matching expenses in the treaty territories. There was some evidence from Dr. von Gernot that there was an inquiry made in 1857, but the evidence suggests that was a pretty cursory examination and didn't take I think it was Mr. Russell, very long to answer a day or two to answer the question, no, not yet. And that was not based on That was based, I believe, on province-wide data, not on data within the territory. It wasn't until 1873 that the Crown turned its mind to increases. The Crown also did little to advert to the interests of the Anishinaabe, much less than protect them. While professing to adverting in at paragraph 273 in 1837, the Crown adverted to the idea that a local government having an interest in the outcome to protect the Anishinaabe would not be the appropriate government to protect the Anishinaabes treaty in interests. And aside from the 1857 inquiry by Richard Pennyfather, the Imperial Crown did nothing to advert to the interests of the Anishinaabe. There were no active steps taken to protect the Anishinaabe's interests. Lots of complaints about it, though. No one insisted on processes and procedures being put in place to protect the augmentation right. Pennyfather simply made a brief inquiry in 1857 and took his response at face value. Instead of insisting that they had a role to play in protecting the interests of the Anishinaabe, the very role that they adverted to in 1837 in the inquiry in 1837 on Aboriginal issues, leaving the fate of the Anishinaabe to the local legislature is exactly what the Imperial Crown did in 1860. They gave complete control over Indian affairs to the local legislature in 1860. And what we have today in 2023 is the result of that decision. As for the province of Canada, and I say Upper Canada became Ontario in 1867. I've got another typo there. I said 1967 at paragraph 276. In 1867, they did nothing from 1850 to 1874 other than Mr. Russell's one-time what I say is a half-hearted response to Richard Pennyfather in 1857. Similarly, if the new Dominion government was in accordance with Section 9124, perceived as a government removed from the local legislature and charged to protect the Indian interests, the Crown ignored that responsibility. The Dominion Crown did nothing to put in place any processes or procedures to protect the Anishinaabe's interests from a provincial government, Ontario, that had control over the bulk of the natural resources within the treaty territory. And in fact, you might recall Mr. Sprague's response in 1873 was, hey, let's just send a letter to Ontario, see what they have to say about it. And beginning in 1873, the federal government, the Dominion government, eschewed any responsibility to actually pay the amount. And what did the Dominion government do? Well, rather than advancing the interests of the Anishinaabe, Sprague limited the augmentation request to the extent of $4 per head, even though Dawson's inquiry was for more. I see we are at 11:15. Would now be a good time?
Yes. I will, we'll break and I will sit back down here. Don't worry about me.
Order all rise.
Thank you. Please go ahead.
This court is stood down for 15 minutes.
Good argument. You laid it out really well. I thought it was nice, well written.
This court is resumed. Please be seated.
So we were discussing a topic entitled "The Crown Did Little to Advert to the Interests of the Anishinaabe in Fulfilling the Treaty." I've made my point about how the Crowns did nothing. I go on and from paragraphs 280 to 295 to discuss other instances. I don't intend to belabor the point here. I wanted to move then to the importance of deterring future breach and encouraging diligent implementation. And it occurs to me that the policy considerations in treaty in arriving at a just award have they share some of the factors one looks at in respect of equitable claims. Both equitable claims, breach of fiduciary duty and breach of treaty engage the honor of the Crown, the principle of reconciliation, and the constitutional imperative of respecting constitutionally entrenched rights. And we say that for all of those reasons, a deterrent effect is needed. An award should incentivize the Crown to fulfill rather than breach treaty obligations. And we say at paragraph 299, if diligent and purposeful fulfillment of constitutionally important rights is the goal, and that's exactly what the MMF case says in 2013, paragraphs 66 to 80, efficient breach has no role to play, and the calculation of losses on what would be equitable like principles would serve to discourage such conduct. Compensation or damages must not be treated, we say, as a license fee for the Crown to choose to pay a price to breach constitutional rights. So we say a defaulting Crown should not have the option to unilaterally decide that it's financially expedient to breach treaty obligations. Whatever the proper role might be for efficient breach in commercial disputes, it has no role to play in assessing compensation for breach of treaty. We say that to do so would be to eviscerate the Supreme Court's ruling that for reconciliation to be attained, treaty rights must be diligently and purposely fulfilled. That's MMF paragraphs 75 to 83. Speaking then of the constitutional provisions, section 35, the honor of the Crown and reconciliation, reading from or referring to paragraph 307 of our material, I remind the court what the Supreme Court of Canada observed in the reference resecession of Quebec way back in 1998. The promise of section 35, as it was termed in Sparrow, recognized not only the ancient occupation of land by Aboriginal people, but their contribution to the building of Canada and the special commitments made to them by successive governments. The protections of these rights, so recently and arduously achieved, whether looked at in their own right or as part of a larger concern with minorities, reflects an important underlying constitutional value. And in the Powley case from 2003, the Supreme Court of Canada called Aboriginal rights constitutional imperatives. In 1999, in Marshall, Justice Binney actually made reference to the Robinson Superior Treaty when he referenced the 1895 Supreme Court of Canada case about what is required, and I've underlined it at paragraph 313 of my material. The term referring to the Robinson Superior Treaty, The terms and conditions expressed in those instruments, referring to the Superior and Huron treaties, to be performed by or on behalf of the Crown have always been regarded as involving a trust graciously assumed by the Crown, to the fulfillment of which the Indians, the faith and honor of the Crown is pledged, and which trust has always been most faithfully fulfilled as a treaty obligation of the Crown. And that's emphasis was actually added by Justice Binney. And the court will also recall, and I've cited at paragraph 315, the 2013 decision of the MMF, by which the Supreme Court of Canada discussed the role for the honor of the Crown in the field of Aboriginal law. I have been through these principles before. I'm not going to repeat them here. The point is that the honor of the Crown is an important factor for the court to consider in fashioning a just award. And at paragraph 316, we observe, as to what amounts to a failure to live up to the honor of the Crown, a persistent pattern of errors or indifference that substantially frustrates the purpose of a solemn promise may amount to a betrayal of the Crown's duty to act honorably in fulfilling its promise. And that is from the MMF case, 2013, at paragraph 82. And so I thus want to make clear that no mala fides or bad faith needs to be proven. What needs to be proven for breach of the honor or failure to live up to the honor of the Crown, which is a factor to consider in this breach of treaty case, is a persistent pattern of indifference. And I believe the evidence does show that. And I believe that an award should discourage such wrongful conduct in the future. So, getting back to the general theme, we do not argue as a matter of law that all compensation for breach of treaty must necessarily be equitable compensation as a result of the equitable type language used by the court or the Crown in the years before and after the making of the treaty in this case. We do, however, observe that the language used and the words chosen by the Crown and in the treaty and by the courts reflect an abiding understanding that the Crown and treaty relationship is a special one to which the honor of the Crown is applied, and it's a principle that long predates Confederation. On any reasonable consideration of the facts, the defendant Crowns, we say, have not acted honorably or with a view to reconciliation. I wanted to turn to two topics. Let's see if I can find it. Part E of our reply. We also, in terms of fashioning a just award, at part E of our reply, discuss Ontario and Canada's position of fashioning a just award. At paragraph 123, we say Ontario's proposition at their paragraph 476 that the court cannot direct the Crown to adopt a specific compensation calculation that would fix the amount of the annuity, we say is wrong. The basis of Ontario's argument for limiting the remedy to a declaration is, as we understand it, relatively straightforward. They argue that the Crown discretion to decide upon that it is the Crown that gets to decide the form, level, and sharing, and that must remain intact. That's their argument, paras 465 and 476. Respectfully, that argument is nothing more than an impermissible collateral attack on the justiciability argument that they already lost and which has not been appealed. This argument should not be given any heft weight at all. It should be rejected. As we indicated earlier, the amended judgment expressly sets forth that it is for the treaty partners to jointly agree on the amount of resource-related revenues to be shared. And if they do not agree, then it is for the court to be the final arbiter of the dispute. And we've already explained why that's an appropriate means. Ontario next argues that the remedies should be limited to the remedies for breach of contract. We say, for the reasons we've already articulated, you just can't pigeonhole this breach of treaty into contract, but you must fashion a just award. I think Canada, we've indicated, has a similar point. At paragraph 486 of their argument, Ontario cites paras 72 and 73 and 78 and 79 of Southwind, arguing that equitable principles are designed to police fiduciary duties. Remember, that's not what the Supreme Court of Canada said. They made it clear that equitable compensation enforces the fiduciary relationship, not the fiduciary duty, but the fiduciary relationship, and deters the fiduciary's wrongful conduct. Our point is, if equitable principles are rightly invoked to encourage respect for and fulfillment of a fiduciary relationship, such that wrongful conduct, admittedly of a fiduciary, is deterred, then in a treaty case in which the Crown remains in that fiduciary relationship, even absent a fiduciary duty, the very same argument rings true. Equitable compensation should be available to enforce the treaty relationship and deter the treaty partners' wrongful conduct. I've indicated at paragraphs 132 and following, Canada's approach appears to follow the plaintiff's position in fashioning a just award. And where we differ is on two aspects, as I understand it. Canada rejects a flexible approach that the Supreme Court of Canada, the Ontario Court of Appeal advocates for when they say fiduciary duty has no work to be done that cannot be done by the honor. Fiduciary duty has no work to do that cannot be done by the honor of the Crown. Remember that from the Court of Appeal. That is consistent with a flexible approach, which ultimately Canada tries to distinguish on the basis that certain equitable principles are unavailable for breach of treaty because they say are highly specific or flow from fiduciary duty. And I say that they've got it wrong here. The two equitable principles that Canada says should not be applied are the presumption of the benefit of hindsight and the appropriateness of including a deterrence element in the award. We say that these principles are not specific to fiduciary duty, nor do they flow from breach of fiduciary duty. These principles are not even confined to equity. The genesis of the presumption of highest and best use does not lie in the nature of the fiduciary duty at play. Canada argues that paragraph 78 to 80 of Southwind stands for that proposition, that the basis for the presumption of most favorable use is the fiduciary's obligation to act in the best interest of the best beneficiary. The case does not say that. Instead, it merely records that there are such presumptions in equity. And I'm not going to go through the lengthy quote from the Justice Karakatsanis in Southwind. It's at paragraph 140 of my material. The court in Southwind does not discuss the genesis of the rationale for employing highest and best use. But I mentioned earlier that Waters in the law of trust does identify it. And at paragraph 141, I cite Waters. I understand from reading the group of seven submissions, they also refer to Oosterhoff as well for that. And I'm sure they'll be speaking of that and when it's their turn. At page 1288 of Waters' text, the author explained that the principle is that evidentiary difficulties concerning the extent of the loss or the value of a relevant property will be resolved against a defendant who wrongfully created those difficulties. This, in fact, is a principle which is well known even in tort law, and this is the reference to the case of Armory and Delamere. So when you're asking the question, is it appropriate to use the benefit of hindsight in this case? If you need to. And by the way, remember our argument is you don't need to actually employ a presumption of highest and best use because the actual evidence before the court takes you to the same place. But if you did need to go there, the court must ask, I think, the following question. Whose conduct created the evidentiary difficulties hampering the ability of the plaintiffs to establish how the annuity money would have been invested had it been paid to them when it was payable and due? Whose conduct prevented the engagement process from taking place in the past such that we can never really know what would have arisen from the engagement process that never took place? Well, the answer is the Crown. Turning to the second area of dispute with Canada is deterrence. Canada argues that no deterrent aspect of an award is appropriate because there's no fiduciary duty. We say again that this is wrong. The rationale cited by Canada in their argument as to why a deterrent component is appropriate or inappropriate in the treaty case is not because of the existence of a fiduciary duty, but it's driven in, if you actually look at the case law, it's driven by the importance of ensuring respect for the enforcement of a relationship at the heart of the duty. We say whatever the duty is. In this case, it's a breach of treaty. In equity, it's a breach of fiduciary duty. In Southwind, and this is a very important, I think, quote I'm going to read in its entirety. At paragraph 144 in Southwind, and this is repeated verbatim at para 145 of my reply, deterrence has a special importance in this case because deterring the Crown from breaching its fiduciary duty encourages it to act honorably and orients it towards the ongoing project of reconciliation. Honor and reconciliation, both elements of treaty. Court continues, as this court stated in Williams Lake, the just resolution of claims arising from the Crown's failure to honor its obligations is essential to reconciliation. given the facts of this case, and we do concede that the court needs to be mindful of the facts of every single case, including Canada's inexplicable conduct, the fact of the land was never legally surrendered or taken, and the significant harm to the First Nation. The trial judge must seriously consider whether the total award will be an effective deterrent, thus reflecting the honor of the Crown and the goal of reconciliation. And we ask the court, in arriving or considering what is a just resolution or a just award in this case, both in respect of the past amounts due, but also in respect of future implementation, to take that to heart. What factors in an award we are going to encourage honorable fulfillment and further reconciliation into the future? And we say that an approach where the court says, I'm going to take a hands-off approach and not give any guidance about the future is not the way to go. What we, yeah.
This is a good time to ask questions on
Yeah.
Your view on deterrence for the past breach, not the forward
Okay.
part of the remedy. But if I understand correctly, you are asking for an increased monetary award as a part of the deterrence portion of the judgment.
That is one aspect that we think is appropriate. We don't place actually that much stock, it's a factor for you to consider. We don't see it as the be all and end all factor. Well, I think the importance of deterrence is actually for the future. That's where I think the focus is. Now, would I say that an element of an enhanced monetary award would help? Yes, of course it would help. But the kinds of dollars we're talking about are so large.
Well, that's where I was going, obviously.
Yeah.
Is it conceivable, the kind of award you seek in the first place, absent any enhancement for deterrence, would not in itself
No, I don't think I can make that argument. I think I'd have to concede that. That's why I say in my material, I really focus on the future, right? It wouldn't be wrong to include in deterrence in the past, but practically the amounts are so large, whether it's, whether it's 126 billion or 127 billion, it still amounts to the same thing. We'll still get the deterrent effect.
I would have said as well, the whatever the award is and the costs of litigation to the Crown.
Yeah, that would serve as a deterrent as well, depending on how the costs are dealt with. And remember, the Ontario has said that we should be responsible for its costs. So, we'll have to have that out at some point. But conceptually, deterrence would be for the past, but I do recognize that the amounts are so large that an appropriate award would be to include deterrence more of as a factor in the future, the particulars of future implementation, because those are the things that are going to help ensure that the Crown gives some thought to the honor and to the goal of reconciliation. And if you'll note, that's why I've actually structured the future relief sort of as, until we can arrive at a better solution, let's just continue on with the Stiglitz and Hutchings model. And of course, it's always open for the Crown to come back to court. But as a default, if we approach the future with, I don't want to say it's not punitive at all, but it's with clear and precise, more precise, a pathway that works, that basically says to the Crown, unless you can come up with an agreement or convince a court in the future that this is not appropriate for whatever reason, here's a pathway forward for the parties to conduct themselves honorably. And we think it's appropriate to actually specify, and we've put what those specifications in our requested relief. We think concrete steps, concrete proposals are appropriate in this case. So I was saying, does that answer your question?
Yes.
Yeah. It's not the existence of the equitable duty that drives the appropriateness of deterrence. It's the importance of the societal relationship at the core of the duty and the need to encourage conduct consistent with the honor of the Crown that facilitates reconciliation that is the import. In this case, it's the treaty relationship that should be encouraged. Honor of the Crown and reconciliation are likewise at the core of treaty fulfillment. Canada also argues at paragraph 87 for the proposition that because the Crown has the ability to balance all interests at play in the exercise of discretion on the use of lands and resources, remedies available should not include remedies that might be available for breach of fiduciary duty. I don't believe that this is an accurate statement of the law. Assuming for a moment that the Crown has the right to balance all interests at play, in deciding how to use the lands and interests in Ontario, that right is not a reason to deny access to equitable principles of compensation. If that were the case, if it were the case that if you balance all interests at play, you don't have to engage in equitable principles, then when it came to a sui generis fiduciary duty, where the Crown wears many hats and balances yet many interests, there could be no equitable compensation. Well, Guerin tells us exactly the opposite, that notwithstanding the many hats, the equitable principles applies. So Canada's argument that the balancing of interests negatives any equitable type remedies is got to be wrong. One final piece of a just remedy is the Brickenden rule. I talk about this at paragraph 152 of my reply. In Southwind at paragraph 82, the court comments on the presumption regarding the consequences of a wrongdoer withholding material facts. Another presumption, the so-called Brickenden rule, applies where the fiduciary breached a duty to disclose material facts. I'm going to pause here. We might not have a fiduciary duty any longer to disclose material facts in the engagement process, but we do have a solemn duty engaging the honor of the Crown to do exactly the same thing. And we do have a situation where the party in possession of the material facts has not disclosed it. Court goes on to say, the breaching fiduciary is prevented from arguing that the outcome would be the same regardless of whether the facts were disclosed. And here we have an issue of, I guess you'd call it onus. In this case, we say the Brickenden rule should apply. And that when it comes to answering the question, well, what would have happened if there was an engagement process? Would there have been any greater amount than what was captured? How much more beyond the 77 billion up to the 126 billion could the Crown have captured? Well, we don't know for sure because we didn't have an engagement process and the information to identify that was kept from us. And the opportunity was lost. And in the evidence, by the way, when this came up with Professor Smart, and I'm just going from memory now, and maybe we're going to have to find you the excerpt. I believe Professor Smart actually said, when I asked him that question, he said that he hadn't actually done the work to figure out what would have happened. So the opportunity was available to the Crowns to lead evidence to say things would have remained the same. They didn't, we couldn't, and the information wasn't available. And the Brickenden rule would suggest that the consequences of doing that fall to the wrongdoer. That's the end of that topic, actually. And so we're going to move on, I think, to the next topic, which is, make sure I've got it, which is causation and could have and would have. And this is covered in paragraphs 43 to 48 of my reply. And I'm hoping I can deal with this somewhat expeditiously. And it's this, as I understand the law, at common law, if you're speaking of a common law, when you have a plaintiff has to prove their case. And in proving their case, the plaintiff has to say, well, I could have availed myself of that opportunity, and I would have, on the balance of probabilities, availed myself of that opportunities. In equity, however, the only thing that the plaintiff has to prove is I could have availed myself of an opportunity, and the law presumes, with the benefit of hindsight, that they would have. But what does it mean to say could have and would have? And Ontario actually relies on a case from the federal court that I think is a good workable definition of the would have and could have. And so I have borrowed from Ontario's argument here. Now, Ontario actually doesn't set out what the would have and could have test is. I did at paragraph 205 of my reply, and I want to read what the case, and I'm summarizing from a case from Justice Zinn in 2019, and it's from a case called, he's referring to a federal court of appeal case called Venlafaxine. Venlafaxine. It's a drug case, and
They could have called it Pfizer.
yeah. So Justice Zinn in Lilly and Apotex in 2019 has a very helpful summary of the principle that Ontario cited but doesn't explain. Apotex text takes this could have and would have language from the decision of the Federal Court of Appeal in Pfizer versus Teva. And then we could have called it Pfizer, which involves a claim for damages under Section 8 of the Patented Medicines Notice of Compliance Regulations. Its analysis and assessment of proof in the but-for world applies to in this case. Now, I know that this case had to do with a particular regulations under patent medicines, but I think it's actually, and I'll agree with Ontario that it's a helpful summary of the would have and could have. And what Justice Zinn summarizes in what I would call the Pfizer case, both would have, in the Pfizer case at paragraph 50, the Federal Court of Appeal noted the necessary aspects of the analysis in this hypothetical world when determining loss or damage. Now remember, this is common law loss of damages. Both would have and could have are key. Compensatory damages are to place plaintiffs in the position they would have been in had the wrong not been committed. Not really that much different than a contract case, which Ontario uses it for, I think, to say, had the contract been performed. Proof of that first, requires demonstration that nothing made it impossible for them to be in that position, i.e., that they could have. Now, I want to pause for a moment because Justice Zinn identifies the would have and could have, and it kind of gets mixed up. The could have is nothing makes it possible for them to be in a position, i.e. they could have been in the position. And let's ask that question of.
Nothing makes it impossible?
Yeah, nothing. What did I say? Oh, no. Nothing makes it impossible for them to be in that position. They could have been in that position. Applying that analysis to our case, you would ask the question, was there anything that made it impossible for the Anishinaabe to secure a 7.2% return in 1850 to 2019? Throughout that period, we say no. And then the second aspect is, and proof that the plaintiffs would have been in a particular position also requires demonstration that events would transpire in such a way as to put them in that position, that they would have been in that position. So could have is demonstrated if you're in a position to take advantage of the opportunity. Meanwhile, would have is demonstrated on the balance of probabilities that events would transpire in such a way as to put the plaintiffs in the position to avail themselves of the opportunity. And we say that on the evidence, and even without the presumption of highest and best use that relieves the plaintiffs from establishing the would have criteria, they would have been in a position to avail themselves of the opportunity to invest. And the plaintiffs say there's ample evidence that nothing made it impossible for them to invest at the rates that Stiglitz and Hutchings proposed. The evidence was that such investments were in fact available, and they were available not only to institutional investors, but investors like the Six Nations who were in fact investing in Britain in 1850. As for the would have component, the chiefs and councils were in a fiduciary relationship with their band members. And the chiefs and council had the legal obligation to act in the best interests of the band and seek out the best possible use of the funds when the money would come into their possession, power, and control. Now, here is an odd circumstance that the facts of history actually benefit the First Nations. the courts have said, and I'm not going to take you to the case law. I don't think it's disputed at all that chiefs and councils stand in a fiduciary responsibility to their nations. And so the question that this court actually has to ask when looking at the facts of this case is whether the chiefs and council, who are culturally attuned to saving for 7 generations and who had a legal responsibility to choose the best investment for any money that would come within their possession, power, and control, and who have a history of seeking out help of experts in matters beyond their competence, what would they have reasonably be in a position to invest in the markets, and would they have likely, based on the large sums of money that rightfully should have been coming in had the treaty promise been honored? And here I've got a reference if you want to see what those amounts is. You can see Hutchins Exhibit 8.1, or you can just look at tab 4 of our material. The answer must be that at least by the mid-1870s, absolutely yes.
Okay, I have some questions arising from this.
Yeah.
So it seems like a long time ago, but in stage 1, there was an actual debate amongst the witnesses on whether the Anishinaabe understood the concept of money.
Right.
And real experts differed on that. So it is hard for me to conceive that if there's some question whether they understood the concept of money, that they would have been investing in the UK. And I distinguish the evidence of the Six Nations from the evidence of the superiors, because that's who Dr. Dribbin was talking about, on the basis of their geographic and other isolation
Right.
from the colonial government or the center of colonial immigration, where a level of commerce was going on that was not going on in the superior territory. That's one question. And the second one is, do you say that evidence of, I can't remember how many transactions there were in that evidence from the Six Nations. Do you say that evidence of those transactions is evidence that that's what was happening? Generally, that's what nations in the superior territory would have been doing or could have been, or that there was ever more than 1 or 2 transactions? Does that evidence give us much at all?
Okay.
Other than a single example?
Well, let's first start with your question about what does the evidence tell us about the Six Nations. Remember that the evidence, I think, from Eric Angel was that it was only the Six Nations that actually had the money to do this kind of investing. And that I acknowledge that the evidence before the court says they did go out to England to invest in England. The fact that they did is some evidence that it was available. And the question is, if it was available to invest in the markets when there was one band with a lot of money.
Sorry, and that's what you meant when they had this kind of money, a lot of money?
Yes, yes. Look, if the court decides that sorry, let me back up. I think if this court were to decide and agree with Bodway and Smart that there was only ever it was really only negative monies for most of the time period, well, then there would be nothing to invest and we wouldn't be here. But the amounts, if the court is with me on Stiglitz and Hutchings model, where there are significant amounts far greater than the amounts of it that are available for the Six Nations. The question is, what would they have done with the money? And this kind of gets into your question about, well, the Anishinaabe in the Robinson Superior Treaty area, the evidence seemed to suggest they really didn't understand the concept of money. They were more interested in what money could do, or what, and this is why in the 1852 petition, they talk about where's our things, where's our benefits from the treaty. And the question would have to be asked if, and let's use a little bit of a hypothetical, you've got a chief in council, and in our argument, when we say annuity monies had to be paid out, if they were paid out to the Robinson Superior Treaty Anishinaabe, they would be paid out for the collective well-being to the chiefs in council. And the chiefs in council would say, I don't know what money is. I know it's a lot. What do I do with this? What do I possibly do? And let's put ourselves as a reasonable Anishinaabe person who saves for 7 generations and who doesn't know what to do with this species.
Well, do they save for 7 generations, or do they look after 7 generations? Because the word save suggests that they were in 1850, when there's a debate about their comprehension of money, and maybe we don't have to stick with 1850. Maybe we should go to 1870 or 1890.
Right.
That their what do I do with this idea is not highly sophisticated if they don't have that experience.
I'm not sure I understand the question you're asking. Let me see if this is responsive to it. I guess the point I'm trying to establish and make here is that the Six Nation, the Robinson Superior Treaty First Nations, what they cared about was saving. There is evidence they cared about saving for future generations and looking after the generations to come. So there is that cultural attunement. We also understand, and I'm willing to accept, that it seems to be they wouldn't understand money per se, but they know that they're trying to get annuity monies that will actually do them practical benefit. And so when this huge amount of money comes in and it can't be put into band trust accounts, if that's what all the parties say, where does it go? It goes to a fiduciary who has a responsibility to invest it wisely. And that's the chiefs in council. And that's the real world factual reality the court is faced with. It doesn't go to individuals to be dispersed as they may see fit. It goes to the First Nations for the collective welfare of the bands, and to a group of individuals, a chief and council, who the Crown has set up under legislation, the chiefs and their headmen, to actually decide how to use that money. And they would have no idea about what to do with that money without the benefit of expert advice. They wouldn't understand investments, but they would seek out help. That's the point. They would have a duty to seek out help, is the point. They are fiduciaries, and one can well imagine that if they didn't do what is legally required of them, there would be consequences for chief and council. The court should not, as part of this process, assume that the chiefs and council would not have honored their fiduciary duty to their nations. The court should presume the regularity of the law and that people abide by their legal obligations and would have done exactly what the Anishinaabe did in the past. And that is to seek out professional help and guidance. And there is every reason to believe that on the balance of probabilities, in seeking out that guidance, the professional money manager would have said, you should invest your money, if you're long-term investors, in a balanced type portfolio. You should invest some in bonds. You should invest some in Britain. You should invest some in the United States. You should invest some in the market, because that's what rich people do. People who have money. Now, you'll note that I said that at least by the 1870s. And you might recall there was evidence from Dr. Dribbin, and let's be respectful to the Anishinaabe, they can learn. They need the opportunity to be educated in ways of money that they were not educated about in 1850. But the fact that they didn't know about investments and money doesn't mean that they couldn't learn. And I believe Dr. Dribbin made that point. And as for rates of return prior to the 1870s, I asked the court to remember that Eric Angel identified that most monies were being invested at 6% prior, in the period 1850 to 1870. Yeah, and in the 1860s, he showed that Michipicoten was investing money in debentures, I believe it was. But most of the rates of return were 6% at a time, and this is important, at a time when there was no repeated persistent inflation, and the 6% would have been viewed by the reasonable person on the ground, in accordance with Ontario's evidence from stage 1, as a real rate of return. And if you add inflation to 6%, it actually exceeds 7.2%. So whether it actually exceeds 7.2% even at 5%. So whether it's at 5% or 6%, the expectation in 1850 was that if there was money, it would be going into an investment vehicle that had a real rate of return of at least 5%, but more likely, more realistically, 6%. But that real rate of return of even 5%, when you add on inflation over each year, is actually greater than the 7.2% we are asking for. So we think that's pretty reasonable. Now, I want to return to whether or not I have answered your questions about lack of knowledge of money and the evidence from the Six Nations.
Yes, thank you.
Okay. It's 12:30 now. Now would be a good time for a break.
Thank you.
And I am in the court's hands as to the timing of the break.
Well, I expect a very short gathering, 15 minutes.
Okay.
So that would make it 12:45, 1:45, 2 o'clock, unless I don't know if it's necessary to fix our return time before we leave this room, but let's try that. Let's try a return at 2 o'clock.
2 o'clock.
Right?
Yes.
Thank you very much.
Order all rise.
Court is stood down until 2 p.m.